Hello, everyone. Welcome to the BFSI Show on ETBFSI.com by the Economic Times. This is going to be the special episode where we are going to discuss the saga of JSW and Bhushan Steels. Courts versus Bankruptcy Code, the JSW and Bhushan Saga is the title we have named for this particular show. The BFSI show is all about talking what happens in the industry in detail with the experts. Why this show? We all are aware that the Supreme Court has recently come up with a verdict which has kind of given a strong feedback to the industry working in the BFSI space, specifically lenders and the insolvency practitioners, in terms of what needs to be done in this particular area. A lot of people have found this verdict very disappointing, while people have found it a lot of gaps in this verdict. But we'll try to understand what is this all about. And let me introduce the speakers that I have with me for this particular show. My first guest for this particular show is Mr. R.V. Verma, the chairman of Inquiry RC and the former banker. Vermaji, glad to have you.
Thank you. Pleasure being here.
My next speaker is Mr. Suman Batra, insolvency lawyer and a very, very famous expert in this particular domain, has been working in the insolvency industry for more than 30 years. Sumanji, glad to have you. My next speaker is Mr. Ashish Kabra, who works with Nishit Desai Associate from Singapore. Ashish, glad to have you.
Yeah, glad to be here, Amol.
My next speaker is Mr. Sanjeev Pandey. He's a CEO of Honorary IP, which is Association of Insolvency Professionals. But more importantly, he was heading NCLT at SBI, State Bank of India, and working with SBI for a long time. Currently, he's also working with DSK Legal. Sanjeevji, glad to have you.
Thank you.
So, gentlemen, glad to have you on this particular show. Before I begin, I just give you maybe a brief highlights. I think recovery was always a major challenge for the lenders, the financial institutions. We had SICA, then we had SARFAESI, the DRT. It did not, prove the merit which the lenders wanted. That's where the bankruptcy code came into the picture. I think why bankruptcy empowered bankers was not only it gave a deadline, but it gave more powers to creditors, and they could liquidate the companies. And that's where the bankers and the lenders got more power with IBC. Came the time when RBI and many other institutions and specifically government found dirty dozen, 12 companies which had huge debt, and bankers didn't know how to actually recover from that. And those dirty dozen companies went to the IBC, which had a huge debt of more than 350,000 crores. Bhushan Steel and Power Limited was one of the top company which had a debt of 47,000 crores, if I'm not wrong, and one of the primary case in this dirty dozen. Now we thought that everything is closed in 2019 when NCLT gave a verdict in favor of JSW, who won the bid and in fact paid 19,000 crores rupees to the bankers. But it looks like something was missing when Supreme Court gave a verdict just a month back that JSW's bid has been cancelled in this particular decision. So Sumanji, let me come to you with this background. And my first question to you now, industry is trying to understand two things. One, what would be the implications of this particular verdict of Supreme Court? Because this is the highest court. We cannot go anywhere. I mean, we can file a review petition, I think, which has been done. And the second is the confidence. How should the bankers deal with the current cases they have? These are the two things that the industry has. But first of all, tell me, what do you think about the process of whole IBC, and why did Supreme Court actually came with such a strong verdict? Were there gaps in the NCLAT verdict? Were there technical issues with the previous verdict? What is it that the Supreme Court spotted in this particular verdict, sir?
Thank you, first of all, Amol, for having me and for a very generous introduction. Before I respond to your questions, I just wanted to say that I have a slight difficulty with the topic, which suggests the courts versus IBC. I mean, I don't see how this or ever in the last 9 years it has been courts versus IBC. In fact, I am not able to recall any reform undertaken in this country ever since our independence, where one particular law reform has become something which has mobilized all the stakeholders, which together contributed in making the law's implementation a success across the board, whether it's the parliament, the regulator, the government machinery, the market players. And in all of these, court perhaps have played one of the most critical roles. Nowhere else in the world, in the last 50 years of the history of the modernization of insolvency laws, including in US, UK, Singapore, Australia, any part of the Europe, have courts made such significant contribution as Indian Supreme Court. They have, in the first 3 years itself, laid a very solid jurisprudential foundation for the IBC. And today, whatever success that has come out of it, there are, of course, certain challenges, which are discussing one of them here. This is because of the great judgments that have come out of the Supreme Court, initially, of course, authored by Justice Nariman, but later by many other judgments by many other judges as well. So I see them all on the one side, but not as verses. So I wanted to dispel that impression for your viewers. Now, I do clearly see that this judgment has set the cat amongst the pigeons. And the reason for that, obviously, is because it has happened 4 to 5 years after the plan was approved, payments had been made, and you're trying to reverse the clock. And it's not easy when thousands of crores are involved. And of course, it makes headline because it causes the shadow of doubt on the IBC, especially because it sort of creates an impression that IBC still is very uncertain, unpredictable, and you could actually have a reversal of a plan approval, even of that magnitude, 5 years down the line. And I do agree that that probably is a setback in terms of the perception and will undo a lot of sheen that we have on the IBC over the last 78 years. But to answer your question more specifically, reading the judgment myself a few times, I did not find any flaw in the judgment. It upholds the IBC. So how could we question the court for upholding the IBC? If it finds flaws in a particular part or a particular way, then it is a matter between the parties. How does the law come into being? Because she upholds the law. The judges uphold the law. They clearly say this part of the law was not followed. They're not saying that the law was wrong. So having found everything correct with the law, and if they feel that the parties or certain parties did not follow the law in the way it ought to have been, and therefore there is something wrong, I do not know how to find a defect in that judgment. Only one thing where I could have disagreed with the judgment, and I do, and I have shared my views with certain stakeholders, is that in a situation like this, not only in a situation like this, but because the law is very clear that if you find certain flaws in the procedure at a certain point in time, then you would ordinarily let the parties cure those flaws, correct those procedural flaws, and therefore let them apply their mind afresh and revisit the situation, undo the wrongs, and come back again with corrected measures. And therefore, you did not need to do that damage. And that's the law. You could always have remanded the matter back to the COC and say, these are flaws, revisit it, come back to me with the clean procedures being followed, and then we'll see what to do. And I think that's where probably one could say that it might just have created a crack through which things start slipping, and that's why we are discussing it today.
That was meaningful thought, Sumanji. I think that was good to begin with. I have more questions and I will come to you, but let me bring others here. Sanjeevji, you heard Sumant also, and I'm sure you must have gone through the verdict many times. The whole issue is with the operational creditors. first in place the operational creditors who went to the court, that shows that their rights were not protected. So in this particular case, do you think that this particular issue could have resolved before they went to the Supreme Court itself?
So, as I understand, see, OCs have a typical waterfall here in IBC. So most of the time, OBCs get a highest haircut, or rather, they go bald. So that is the fundamental of the code, and that has been challenged many times in the court. The OC says that we neither have any say in the COC, and nor do we get anything. Even they initiate the case, ultimately they go without their hands free, with nothing in the pocket. So that is something with, I think, the lawmakers are also struggling with, how to take care of the OCs here. That is one challenge. But I think in this judgment, OCs was not a big factor. ED, of course, came in. ED was a factor here. ED created some problems at the stage of resolution, and the amendment that 31A came later. And actually, I was at SBI. We were part of that process. We recommended those kind of suggestions. And I remember we also gave a presentation to the finance committee. So some 15-20 MPs were there. We gave a presentation exactly on that 31A. So, and here the NCLT applied it. Actually, this law came later, but they applied on the existing case. So that was one problem. And I totally agree with the Batraji. There were a lot of gaps in the process by the RP, by COC, by everyone. But one thing, as I have learned the law right from being in IBPA and then in bank practicing it for 5-6 years, that ultimately IBC says the law is for resolution. So in one word, if you can define IBC, so IBC is for resolution of an entity which is feasible and viable. You cannot kill that entity. Till the time it is viable, so COC has to approve and the court has also approved. So whatever may be the process, that is where I may differ with Sumanji, that ultimately I agree that the judgment is flawless in terms of the provisions of law or regulations of CRP and all that. They were not met. But finally, an alternative could have been found where the Supreme Court could have allowed the second highest bidder, to chip in, like they did in recently in the Hindustan National Glass. The top bidder, their plan had some problem. They did not go to the Competition Commission to take a advance approval. So that flaw was there. Same Supreme Court allowed the second highest bidder to match the bid and come out as a result. So because ultimately IBC is for resolution. You cannot kill and here the top thing is resolution has been achieved. Now killing a baby, once it has been resolved and after 5 years it has become a healthy company, taking it to gallows is something I differ with this. That's the only thing.
So I copy your points, and in fact that is the worry that the whole industry has, because in the last 5 years things have changed dramatically, and it's like undoing a marriage which was done almost 5 years back. But Sanjeevji, my immediate question here is, I mean, I will come back to you whether what Supreme could have done and whether they would have chosen the alternative. That's another question which you have pointed out. But my simple question to you is, when IBC came specifically for resolution, you look at the data, majority of the cases went for a liquidation. The focus was not more on the resolution, but the liquidation of the companies. Was it because the bankers were in a hurry to get the haircut and clear the balance sheet as early as they can? Because similar things happen to the Videocon and so many other cases where the small lenders, like in perhaps in a Videocon case, Bank of Maharashtra, were actually going to the NCLT again, because the large players, maybe large consortiums of the banks, were happy with whatever the haircut they were taking. So is it in a way directly or indirectly we are not looking at the operational creditors or the small creditors?
No, so as regards liquidation, originally you see the latest data of IBC CIRP cases. So now in 24 or 25 data for financial 24-25, the resolutions are more than liquidations. So that is the latest data. After 8 years, we are at a stage where resolution exceeds liquidation. So if you go back in the last 8 years, initially a lot of these BFR cases which were pending in high courts, they came to IBC. Then there were winding up cases pending in the court. They were transferred to IBC. So those were defunct companies. So law says you can save a company which is feasible and viable, which can be revived. You cannot save a dead baby. Something is already dead. You cannot revive that through CRP. So fundamental is that the COC, within its power and commercial wisdom, has to decide within the first or second COC meeting whether this unit which we are working on CRP, is it revivable or not? Is it something viable? So it is worth saving, or should we take it to liquidation? So that is why law is designed that you cannot apply CRP for liquidation. You only apply for resolution under the law. So law clearly says attempt resolution first. If you don't achieve it, then liquidation. Second part of the law is that under the law, liquidation can happen only in 3 instances. There is no resolution plan received. At the end of the CRP, you invite EOIs, no plan comes. You take it to liquidation. Second is plan is received, not approved by a required majority. 66% not achieved, take it to liquidation. Third is court find something bad in the plan which is not as per the code. They reject the plan, company goes into liquidation. And fourth point is when the plan is approved and not implemented, again, one of the creditors or any stakeholder goes to the court, says, sir, plan is not being implemented, take it to liquidation. But what the Supreme Court has done here is out of these four, because that's why they applied Article 142, their extraordinary powers. So that is something strange to me. Okay, a company which was resolved, which was viable, feasible, today it has thrived. It has multiplied the capacity. Why take it to liquidation? Because it is a loss to society, to the industry, to the nation. So that is something which is not. Yeah.
Sure. We'll come back to you. I will also request the audience, if they have any questions, please keep shooting your questions. I will try my best to take it with the speakers that I have. Vermaji, you heard, Sumanji and, Sanjeev sir already, and the conversation is going on specifically on this topic. What do you hear now as a banker? And I'm sure you must have had discussions with the bankers. How the bankers are looking at this particular verdict? Are they worried? Are they disappointed? What is the next level of strategy they're planning? Because every bank has dozens of cases which are being heard in NCLT, and they're processing it for the IBC.
Yeah, thanks, Amol. The very interesting insights which I heard from both Sumant as well as Sanjeev Pandeyji. My view is that you see, IBC has been a very bold step, very bold measure, and prior to IBC, the recovery proceedings, etc., the systemic gaps were there, huge amount of systemic gap, and the recovery framework itself was very fragmented. IBC was a very major step in terms of putting all that together, consolidating all the past initiatives and the efforts, and putting them all comprehensively in one code as a statute, and then moving forward. So that was at a time when the reform measures were at its peak, and the global financial sector reforms were actually going ahead, and we were still lagging behind. So this was one very major piece of financial sector reform, which was actually enacted by the government. Now, particularly this case assumes importance, keeping in view the enormity of it, the magnitude of it. But the point to note is that this was a 2017 case which started, and IBBI itself was constituted in 2016. The IBC was still at a very formative stage, and it was so overarching that it required a lot of evolution. So that, keeping that big picture in mind, I would say that while this particular judgment it amounts to some taxing time for the industry, it's more than that, it is testing time for the IBC. So we have to learn and move forward. As far as the Supreme Court verdict is concerned, we can't find any flaw in that. We can only assess the outcome of this and the impact of the judgment, and that is definitely negative in terms of the sentiments of the industry, the the sentiments of the creditor institutions, the sentiments of in the economy overall, and in the sentiments of all the stakeholders. So we're just assessing the outcome of that. On the other hand, it sends out a very strong signal to the stakeholders was involved in the process of implementation of the IBC provisions that you better be particular and very specific about the process involved. The process is also a part of the law, a part of the act. So that can't be ignored, that cannot be set aside. So you have to be very particular about that. And that's, I think, a very strong signal from the Supreme Court. But having said that, when we look at the factors, the factors which caused it, and the compare that with the outcome of it, I think there is a lot of disproportionality. So it could be processes, small processes, which could have been maybe revisited, reviewed, rectified, and the outcome which is coming now could have been protected. So that's a much larger issue, given the amounts. I mean, the objective is exactly being reversed. One of the important outcomes of fallout of this judgment is that the objective for which the IBC was actually instituted and codified, that objective is actually, we are failing to achieve that objective. And exactly the reverse of that is happening. So that's something which is very important from the economy point of view, from the bankers' point of view, from the corporate point of view, from investors' point of view, not only domestic but global. So IBC was being watched globally as well. So that's a kind of I would say it slows down the process and the confidence of all the stakeholders in our economy and in the resolution process itself, that does receive a kind of a setback. But I'm sure going forward with adequate reforms and covering these gaps, these can be addressed. So there is no issue. IBC has seen evolution over a period of time, and I'm sure we have reached an important milestone where something very important has happened. But I'm sure it will get fixed by all the stakeholders as long as we have a very constructive and positive mind. I'll leave it at that for the time being.
Okay. No, sure. And I will come back to you. In fact, want to know more exactly in terms of how specifically the bankers will look at it. They are not very open even after a month, but we'll still try to learn on that front. But Ashish, let me come to you. See, good, bad, right, wrong, that's a different part. But Supreme Court judgment has highlighted couple of technical points and which are absolutely valid. It has specifically pointed out the delay in the process, the silence of the COC in delay in bidding, and all those things. So it has already, in some manners, challenged the whole process of the IBC. Don't you think so? Could we have stopped that? Is there any way we could have rectified it? And how insolvency professionals and whole IBC network will look at it now?
Sure. So let me start by addressing exactly what happened or what Supreme Court viewed in context of the delay that had occurred. Now, under IBC, there is or at least there was at the time when this particular process was being run, a mandatory time frame of at least 270 days provided under law for completion of the insolvency process and to have the plan approved. Now, that time frame was not adhered to, and actually the time taken, as the court found, was much longer. But what I don't see any analysis in the judgment about is what really transpired in the background during that entire period, or the elongated period that it took to have the plan approved by the Company Law Tribunal. And as I understand, this was one of the first insolvency cases, part of the Dirty Dozen, which was sent for resolution under the IBC process. So the whole IBC process itself was quite new for all the stakeholders that were involved at that point in time. Further, there were multiple rounds of litigation that took place even at that stage when the plan was being considered and approved. And obviously, when such litigations are taking place, the process automatically gets slowed down and dragged down. In fact, the judgment records an NCLAT order which requests that large part of the period that was spent be excluded from consideration of the mandatory time frame which was there at that point in time. And therefore, while the Supreme Court does find that the period which was there, which took, was in excess of the mandatory period which was prescribed under the law, there had to be some consideration of also what really transpired in the background at that point in time, and those factors could have been taken into consideration. That said, what is the whole rationale of having a mandatory period prescribed under IBC for completing the resolution process? It's again to protect the interest of the stakeholders and primarily the creditors. It is the creditors who will suffer if the whole process is dragged out, and the company itself, underlying company, which will suffer if the process is dragged out, because you have an IRP managing the company during that process. The creditors are left in lurch and are not getting their money by the delay in the process. So their interests are being hurt. And now, if you look at the outcome of the judgment, it is precisely hurting those very interests itself by looking at the delay which took place. So that approach, again, identifying that there is a delay and correspondingly saying that the plan ought to be set aside, is something that does not sit well, at least at my end. And last, if you look at this data, and my colleagues here earlier pointed out to various data points, if you go back and look at the data, even back in December 2018, there were more than 250 cases where the CIRP timeline had exceeded the prescribed period, that is 270 days. So then what happens in all those cases? So clearly, there is an issue even with the timeline and the way this was analyzed, and the outcome that was then prescribed as a result of non-compliance with the timeline. Now, also looking at it from the bankers' perspective, and it's not just the bankers, right? It's also the market is not just public debt or public sector undertakings. It's also private capital, private debt, which is out there. For debt funds, what precedent does this judgment set? They have raised capital from their investors and deployed it and are looking to recover it. Upon recovery of their capital, they will distribute it onwards to their investors. Now the judgment asks the capital to be returned back to, in this case, JSW, but in general terms, a successful resolution applicant. Now, where will the private debt funds in these circumstances recoup those capitals? Or if such a situation were to take place and this becomes a precedent in other scenarios. So obviously it creates an issue for the industry. How do these funds will actually now bid in the process moving forward? So these aspects need to be considered and looked into as we go in. And I think the last point that you raised was from the IBC professionals' perspective. What do they do? I think from their side, judgment indeed, at least on one end, does point out issues which were there in the process. And therefore, it is a cautionary tale or cautionary note for them to ensure that they at least are extremely diligent while undertaking their duties to ensure that these procedures are complied with.
Okay, I think great highlights from all of you. Very different perspective on the same judgment, and I think it's quite engaging for me to learn from all of you. Sumanji, let me come back to you. And there is a theory. Everybody has a different view, and everybody is reacting to this judgment in a different manner. But there is a theory that the Supreme Court could have rescued BPSL, I mean the Bhushan Power and Steel Limited, using Article 142 by not liquidating it. Any thought on that part, sir? Because this argument of this particular point is getting some interest in the discussion points, specifically in the insolvency professionals.
So, Amol, before I respond to your question, just a very quick reflection on what everybody else on the panel have said, and I think they made all of them very valuable comments. But I think we seem to be all very unanimous, at least on one thing, that the end note of the judgment could have been different. Sanjeev said there was no need to go to the extreme of ordering a liquidation. He suggested that perhaps the second highest bidder could have been invited. Ashish said that, the delay, I mean, you sort of frowned on the delay, but you yourself have created more circumstances for further delay. And then, of course, Mr. Verma very rightly put that perhaps the implication of the order could have been thought through a bit more deeply as to how it might impact the sentiments of the market, as well as the perception for the investor. We are at a very delicate stage where we're wanting to become a developed economy. And these kind of setbacks do really set a bit of a crisis situation. And I said, therefore, in my opening comments, that what perhaps is not coming out of the judgment is, did the Supreme Court explore, or were there suggestions from the lawyers to explore that in the event the judges were not persuaded by the parties that the decisions were right and the process were right, Was there a plan B put to them, to the court? The plan B could have been, these are all curable defects which you have found, the three of them, as far as the process is concerned. There is no substantive wrong on the IBC found. And if it is just the process, then could you not just have sent it back and said, rerun the process, do it in 30 days, come back to me with a process? That way, you didn't really have to go into the extreme situation of pulling the shutters down on the enterprise itself. Now, having said that, you asked that could the judges have exercised Article 142? In my view, if the end note was what we were just discussing, that remanded back to the COC, we didn't even need to go into the need for 142 being invoked. I think the Honorable Supreme Court was cautious in invoking 142 because just a few months back, in two very big judgments, Jet Airways and Baiju, in both, they had very clearly said Article 142 in IBC cases should be exercised in rarest of rare cases. Now, if it is done to benefit one party, because it's on merits of the case, right? Having found that the process is flawed, and if you exercise your power under 142 to say, I am willing to shut my eyes so that one party can benefit, even though I understand the collateral damage to the IBC, it doesn't send the right message to the market, in my view. And it sets a precedent, then everybody will say, oh, it will cause damage to IBC, it will cause damage to me. And it's not just in this case, it will be in all economic cases. And that is something we cannot afford again, because we need a market discipline in a free market economy also. It's not free for all. And therefore, I think the cautious approach in that is fine, not to exercise 142. But yes, the end note, as I keep saying, could have been different. Instead of liquidation, it could have been sent back for the parties to correct the error. And in that process, if the COC would have decided to invite any other party also to put in a plan and do it. And mind you, the values have gone up since then. And the commercial values would have changed and dynamics would change. So I'm quite sure that the judges are very smart. Let's not just think that judges do not understand IBC or the judges do not really understand the implications of their decision. They are very, very smart. They understand, and we can have these emotional outbursts. We can create a kind of all kind of headlines out of it. But the fact remains, they are very responsible institutions. They understand what they're doing.
And I think there were precedents in JP Infra. The entire process was rerun. Sumanji was part of the advisor. So the entire process was rerun again. And they reached a conclusion, a resolution plan.
Yes. I mean, I think if they would have done that, we all would have been sitting in the COC discussing rather than, here. But having said that, I mean, I do feel that you will be surprised how it might end in a few weeks. And in fact, everybody might just be celebrating because everybody is trying to control the damage to make sure there's no damage to the law, no damage to the enterprise, no damage to the lenders. And of course, the remarks that have been made against the RPA, COC, and everybody also, that's also a concern because the lenders are more concerned about the remarks that are made against them. Money will come, not from A, but from B, but the remarks are scathing. And I think their concern is that they should be done away with. That's what probably is bothering them more than anything else.
Right, sure. So Sanjeevji, that's what my next question was, and I think Sumanji has elaborated in terms of the processes and what exactly happened. But course correction measure, if we were to focus on that now, can it happen? Can situation really change? Because it's ultimately a Supreme Court judgment. The review petition and everything has been filed. But how the course correction measure will take place? Ultimately, there has to be a process now where the banks will have to refund the money to the JSW. They are already in a silos. And such verdicts actually create ripples into the market. I think what I remember is the Supreme Court's in the past, the bold judgment where they canceled the licenses of 122 telecom companies. And suddenly there were enough disruptions in the market. This verdict reminds me that. So how do you think the whole course correction measure will happen now?
I think that let's hope that some review positive review happens for this case, because unwinding this transaction is, I think, a nightmare for the banks and even other stakeholders. Like because balance sheets have been finalized, taxes have been paid, some OCs have been paid who may not, or some even money has been paid to companies who or
Right.
entities which no longer exist. So you cannot recover that money from them. So both unwinding this transaction would be a hell of a nightmare. So I just hope that something positive comes out of the review. But then, as regards course correction, I would only say that a lot of course correction has already happened. This case, as Vermaji said and Ashish also highlighted, this was 2019, 18, 19, 17, when case started in 17, concluded in 19, and then finally implemented in 21. That is the timeline. So now we are much more mature in terms of understanding of IBC. IPs are much more monitored, much closely. I think IBBI is much more active in monitoring IPs and training them and everything. COCs still, I feel, because I was at the helm of SBI NCLT division, and I did my best to set up policies, SOPs, circulars to set the things right. Because one major challenge which COCs face, especially the banks and institutions sitting in COC face with IBC, is that the timelines are different for both. IBC runs on a very, very tight timeline, 180 days. Banks normally for approving a proposal takes anything from 3 to 4 months. Even today, even when totally it is computerized, still a proposal of this size, 5 to 10 or 20,000 crore, can anytime takes 3 to 4 months or 6 months to process. So these are very divergent decision-making processes. IBC expects the person sitting in COC to vote instantly and take a decision. But as the banks work, bank don't work like that. Bank, no single person is authorized to take a decision. There are committees, and decision like this, approving a plan or taking it to liquidation, they have to go to the highest competent authority. And this competent authority sits only once in a month, these committees. So, and the entire 80-page proposal has to go there. And that proposal has to be comprehensive, complete. Making that proposal itself takes 15-20 days. So, this is a challenge. We also tried in SBI to cover up. We came out with some guidelines like how to cover this gap. And I think banks are still working on that. Another challenge is that bankers who sit in COC, there's a lot of churning happening all the time. As my colleagues from banks will know, that banks have a policy of keeping a person in that position only for maximum 3 years. Generally, most of the banks have that policy. Now, a person who comes to the stress asset vertical, he sits in a COC today. Maybe after 6 months, he gets transferred. New person comes in. He may not have heard about the IBC, and he goes to the next COC. How can you expect from him that he will apply his judgment, commercial judgment, and do everything right? So, lot of training, lot of hand holding, lot of things is required, and that is the cause of delay also. When people don't understand, they don't decide. So that is one challenge for COCs. And I think these remarks, Batraji rightly said, there is a tension among banks about the remarks. But I will say that because I tried my best to enlighten my colleagues that be very sensitive to this law. This is very, very critical law, and you are in COC. So banks generally think like sitting in a COC is something similar to sitting in a consortium meeting. They are very different things. COC, you have powers. You have powers given by the code, by act of parliament. You have to be very, very judicious and cautious. And whatever you do, you have to record. That is something I found missing in most of the plans went through me or when they were approved. That COCs were very, very laggard in recording what is their commercial judgment. That is what is hitting them. Here, had they recorded why did they approve this plan, why this party is H1, they did not even declare H1 here. So these are some missing points. I think COC should learn for the future cases that whatever you discuss, your commercial judgment should come out in your minutes. It is not that we have applied. No, you have to justify, you have to explain how you apply. So now that is being questioned.
So basically, I mean, it's not going to be easy unwinding of this whole, judgment, because there are so many stakeholders involved. That's what the fair point. I have a couple of questions. I think a few of we have already discussed, but I think this question, I think Ashish, you can take this question. I think this is more on the review petition, in which we were supposed to discuss. Ashish, the question is, can this judgment be challenged by JSW Steel or other affected parties through mechanisms such as review petition, curative petition, or other legal avenues? And what specific grounds and legal thresholds must be satisfied to successfully challenge this ruling?
Sure. I think it has already been challenged,
Yes.
and the review petition is already pending before the Supreme Court. And as part of that review petition, the proceedings in it, the Supreme Court has also ordered a status quo on the earlier judgment, ensuring that no liquidation process commences while they determine the review petition. So that's already there, and in the initial sort of interim position that the Supreme Court laid out, if anything, is if indicative, and I stress on if, uh, does give certain hope to the industry. That said, the scope of a review is extremely narrow, and that has been highlighted how the judgments were mentioned earlier on this session itself, where Supreme Court has said that 142 should not be exercised. That's their sort of overarching power. Equally, review is also very narrow. It's not an appeal. It's only in scenarios where there is grave miscarriage of justice or some glaring or apparent error. Now, whether that error exists or not is again a very subjective exercise, and we can all argue both ways, either way. As Suman sir also mentioned, that at the end of the day, the court did find that there were issues in the law and the process which was there. And IBC requires those processes to be mandatorily complied with as well. And therefore, it could be argued both ways. And it's very difficult to state with certainty where Supreme Court will go or such a process will succeed or not. But you have to take the chance, which JSW has taken. Now, what would be the thrust of their arguments? Again, I won't presume to act on JSW's behalf here and lay out those. But the key issue which we've seen is, say, for example, the court looked at and found that the necessary declarations in context of Section 29A, which is a provision which prevents the promoters or other ineligible applicants basically coming in and acquiring the company through the IBC process. Now, those declarations were not in place. The question one may have to ask is, what is the prejudice that was suffered on account of those declarations not being in place? And how do we resolve that? And I think that's what been discussed earlier. So somewhere the focus of presumably the JSW, anyone who has moved the review petition, or the parties that have moved the review petition, I believe the COC as well, will sort of bring focus back to those aspects. And then hopefully there is some resolution on each of those fronts, and we get to see that the process still continues move forward. And more importantly, quickly. The more time this whole process lingers, the longer the sort of debate remains in the eyes of the market, in the eyes of the industry, and so on. So we also hope that it will be closed as quickly as possible.
Okay, I think that gives me a segue to ask another question to Mr. Verma, specifically on again bank's perspective, because there are two questions related to this. What is going to be the bank stand? So immediately, sir, the question that everybody has is now: will banks go slow on the current cases which they have, and they will wait for the JSW verdict or JSW Bhushan Steel's verdict? What happens in this particular case, because they do not know if something goes, whatever happens with the NCLT, with the whatever cases they are running, it might go to again Supreme Court or something like that. So is it a very low confidence kind of an environment in the banking right now? Are the stressed asset heads really stressed now?
Yeah, I said right at the outset that it's very taxing time for the industry, and it's of course testing time for the IBC. Having said that, to your specific question, it's definitely a downer, a big sentiments downer for the market, for the banking industry. And again, I'd like to repeat that aspect, where some kind of matching of the gaps by the applicant institutions and the verdict. The two are very disproportionately, measured against each other. The gaps could have been probably, or if they would apply for it, there's something technically they may not be right. The faults are there, technical faults, but it's not something on which you kill a particular entity which has a huge economic value and which was still playing out in the industry, and they had actually besides the amount which they had paid to the creditor institutions, they would have made lot more investments in manpower, in all kinds of areas. So you are basically trying to protect, the IBC tries to protect the economic value of an entity, and bats for speedy resolution so that those values don't deteriorate. Now, that being the central objective of the
Hmm.
IBCA,
Right.
this is doing exactly the opposite. So bankers are definitely, at sea with the judgment, and while they would know that yes, these are technical points have been raised, but
Right.
at the same time, whether there was a process of condonation, there are
Hmm.
condonation of delays also, which happens, in some cases. It's, of course, it's for the honorable court to decide, but something
Hmm.
like that, because the outcome is so disproportionately harsh,
Right.
not only to the entity but to the economy overall, and
Hmm.
which runs against the spirit of IBC provisions. So
Hmm.
that, having taken that into account and taking cognizance of that, probably the applicant could have moved the honorable court for some kind of a dispensation, where there could be some condonation, provided they are able to do certain A, B, C, D, some such thing. I don't know whether that was explored, but that was a way out of this kind of a, it
Okay.
was a faux pas. It was a faux pas which was actually done by the institutions, but which
Hmm.
resulted in such enormous fallout. So that's of course important. That's being looked at by the banking industry with a lot of kind of demotivation, and I'm sure the banks are would be, but I'm still we are very
Okay.
hopeful that the last word on it has not been said yet, though the scope of review could be very narrow, but the scope of review increases. I mean, it's becomes much broader when we look at the other side of the spectrum as
Right.
to what's the impact on the economy. Then the scope for review automatically goes up. So if it's a technical fault and then the result is so huge for the rest of the economy, not only today but in times to come, so you have to measure all that and the kind of cost which it implies for the entire economy. And I
Hmm.
think the political dispensation should also be concerned about it, because it's the IBC issue. And IBC, all said and done, it was very bold step, and I still am of the view that it has evolved over a period of time. There have been gaps in implementation in certain provisions which have been gone on being modified, and it has been getting fixed from time to time. At this point of time, there's something which is more serious than anything else in the past. And considering that the whole process was just after the IBC, 2017 onwards, as Pandeyji also indicated, the timeline, keeping that in view, it was still learning, it was still evolving. The industry was still learning the nuts and bolts of it. So keeping that in view, I think there is a case for condonation of the technical errors which happened. And I'm sure while at the time of review, there would be a sense of the disproportionate
Right.
fallout of that, or the impact on the economy and the banking industry, on the investor community, and that impacting the broader economy going forward also could be a very major criteria for doing a
Right.
review in right earnest and in right spirit.
So what I will
But
do,
a
gentlemen, here
short
is
point, short point, Amol, to you is that
yes.
yes, banking industry is certainly a very uh, disappointed, and for the two major banks, PNB and State Bank of India, definitely the cost could be very high, and for the industry overall, having industry we all understand, but specifically now to the parties involved in the process, the creditor institutions, JSW would have raised funds from other sources, as well as Ashish also mentioned, say PE funds, etc., who raise
Yes.
funds from their own investors. So it's a kind of a very interconnected industry, and the risk also gets transmitted very quickly. So keeping in view the entire dynamics of this entire ecosystem, I think the honorable court should be prayed
Okay.
and requested for a kind of condonation, if that is within the realm of possibility.
Amol, can I make just quick 30
Sure.
second
Sure.
point?
Sure, sure.
Well, I think Mr. Verma was very eloquent and persuasive, and I hope he stands in court next to these
Mm.
Solicitor General and makes an argument, because this is exactly the kind of argument that we need to make in economic cases. The damage it causes to the enterprise and to the economy at large, and I think what he expects is the aspiration of the bankers, and I hope it will resonate with the courts, and the outcome would be exactly what he suggested, something that is proportionate and not disproportionate. And the only one thing that I'd like to add is that at the same point of time,
Mm.
while it is all fair to expect that kind of relief from the court, and I'm sure it will come,
Mm.
we all believe that the outcomes will be different once a certain exercise takes place. But at the same point of time, we should not create complacency in the banks and the resolution professionals that they can be casual about the process, because
Right.
it's important that the sanctity and the credibility of the process is also maintained, because that is also equally important to the investors community abroad, because they want to understand and they want to have respect for the integrity of the process, so that it does not get shaken later in courts. So it's
Mm.
equal duty of the banks and the other stakeholders to maintain the integrity of the process, which Sanjeev also suggested, to understand that they are public trustees, they're carrying huge responsibility on their shoulders, and
Right.
they must discharge that responsibility honorously and completely honorably.
Mm. No, certainly, certainly. I think the time is now limited, but I just have one common question, and maybe all of you can just come, maybe share your conclude with 30 seconds or something like that in terms of what next. Wama sir and many of you also, I think, agree in one way that there has to be a case of condonation. There has to be a review petition for a betterment of the economic losses, which is going to happen after this particular verdict, should be reduced and everything. And for the large benefit of the lenders or the banks, what next? What should be the argument in the review petition? How should Supreme Court look at it? How do you see the whole case going ahead? Just last concluding remarks from everyone.
So I would
Okay,
say
Sanjeev
that
sir, you can start and then you can go ahead. Yeah.
yeah. So I would only say that the Supreme Court should deliberate on the judgment and see what justice was delivered here. Like they gave a very nice, sound judgment, perfect in the law. The same time, ultimately, who got justice here? Whether OCs got any justice, because whatever money they got, they will have to refund that.
Okay.
It is not a social justice in any case. So many people will lose their jobs. Many vendors will lose their business. Government will lose their taxes. So it's not a social justice. Economic justice, is it justified on economy? No. Even legally, also no, legal justice was also not delivered, because law says resolution. So you are taking a resolved company to liquidation, even legal justice is not delivered. So I think that is something to be deliberated upon during the review, that what kind of justice are we delivering while giving a judgment. Because ultimately law is for society, law is for something good, whether it should be social good or economic good, it should create something good. Here, what are we creating? So that is only briefly I can say.
Sure, sure. You raised a lot of questions.
If I can, yeah, if I can come in,
Sure.
just
Yes.
quick comment.
Yes.
Other than, I mean, if one has to approach the court, other than the disproportionality part of it, we should clearly highlight the kind of impact it makes or the distress it brings to the entire economy. That is one, and number two is how the liquidation in the current form of the order is going to be so counterproductive and in a way, as Mr. Pandeyji mentioned, the nightmarish for all the institutions. That's something which the court should keep in mind, in the sense that if that can be mended through some kind of even passing strictures, that's fine. I
Right.
mean, has to be taken very, very seriously. It is taken seriously because it's coming from the honorable court. So even at the cost of doing that, and the situation, the current structure or the dispensation of the proceedings protected in view of the background, the
Okay.
recency of the IBC when this issue was taken up, the reference by the RBI to the insolvency of these 12 companies for insolvency, because the NPA issue was very big in the entire banking industry. So to counter that, this was taken up, and the entity had, I'm not holding a brief for the entity in any case. The entity and to be very practical, I mean, they did mobilize their resources, everything. I mean, the intellectual resources, their own financial resources, their operational resources, to be able to handle that, and make the gaps good to the creditor institutions, being the banking two big banks who received the money,
Right.
and they treated their NPAs, reversed that, took the benefit of that. They got a lot of tax concessions on that too, which there's another fiscal issue is there, which also comes into the picture, which will need to be reversed again by the tax authorities if it is. So the impact of unwinding this is something which
Right.
should be clarified and brought out very clearly to the court. One is the disproportionality of it, and number two, the impact of unwinding, how it can make it even more disproportionate, or make it almost kind of, it may create so many other NPAs in the industry. So that will again run against the very spirit of the IBC and the RBI's reference to or bringing these companies into insolvency. It will just reverse that.
Sure. Ashish?
Sure. I think had this SLP or this Supreme Court given this decision back in 2020, we probably may not have been discussing this. And had the underlying two benches, that's the NCLT and NCLAT, not overlooked the procedural lapses, again, we would not have been here discussing this. So somewhere it is not purely the procedure which has led to this sort of situation arising. There are also other factors which have come into play to giving rise to this situation. And while we have discussed what was the issue there and how it has impacted here, we could probably also focus a bit more on resolving some of these issues as well. And obviously there is a widespread acknowledged fact that there's always been a constant demand to increase the number of benches in NCLT,
Yes.
also improve the functioning infrastructure, so to say. And I'll just echo that. And I think that has been echoed across by the Supreme Court, by Parliamentary Standing Committee on Finance, and so on. So I think that definitely is something that we could work on and try and improve. And maybe as an outcome of that, it combines with what the insolvency IBC connected professionals are doing, would lead to a sort of avoid this kind of situation arising in future.
I mean, that processes of NCLT benches and all could be another topic of discussion for an hour for sure. I purposely didn't touch that, but thanks for adding that. I was about to close, Sumanji, but give me 30 more seconds because I have received one interesting question and I want you to answer that. This question is, could this judgment establish a legal precedent that allows for the reopening of previously concluded transactions through the new case filings?
Well, no, because where the limitations have gone away already, and the time has lapsed, I don't think fresh cases can be fraud. The only exception is fraud. Other than if somebody is able to bring out an element of fraud, any case that has been put to rest and the limitations have expired, however glaring the procedural lapses might have been, or the flaws in the procedures, I don't think they can be reopened. And that is not something which I think we should fear at all. These are unfounded fears. And I feel that, all our anxiety will be put to rest in a few weeks, because exactly what has been stated by Mr. Verma, Sheesh, and Sanjeev is what I'm sure the wisdom of the people who are going to argue is going to capture. And essentially, I'm sure that the judges would be persuaded to review in whatever form to undo whatever damage, to the extent possible. And I'm quite optimistic.
Right. Sure. Noted your points, and I must say thank you so much, for the meaningful time that you shared here and the meaningful thoughts that you shared here. Thank you so much, Sumanji, Sanjeevji, Ashishji, and Wama sir for, being part of this particular conversation. And thank you so much, the dear readers and viewers for staying, with Economic Times dedicated vertically to BFSI.com on this particular show. Thank you so much, sir.
Thank you.
Thank
Thank you,
you for
Amol.
having me.
Thanks, everyone. Thanks, everyone. Bye-bye.
Thank you.